Good afternoon, everyone, but most importantly, happy Friday to you all. My name is Rashad Green, and I'm the current president of the Tampa Lawyer Chapter of the American Constitution Society. As today's host, and on behalf of all Florida lawyer chapters, I'm excited to welcome each of you to today's third annual 11th Circuit Year in Review series. We're super excited that you decided to be with us today, and we're glad that you support us, and we want to continue to see you here with us. ACS is a nationwide nonpartisan and nonprofit network of progressive lawyers, judges, law students, and community leaders dedicated to advancing and defending democracy, equality, and the rule of law. The Florida Lawyer Chapters regularly host events on key legal issues and best practices, and we also work closely with our local law school chapters in advancing and mentoring the next generation of progressive leaders. For more information on ACS and to learn more about how you can get involved, be sure to visit us at acslaw.org. So today we will engage in an in-depth discussion of some of the 11th Circuit's major decisions from 2020. Each panelist will have 15 minutes to dive into the substance of their case that they prepared to discuss today. Questions from the audience can be submitted at any time during the presentation using the chat feature. At the end of the review, the moderator and the panelists will have 10 minutes to answer any questions from the audience. So let's introduce today's moderator and panelists. Today's discussion will be led by the Honorable Monte C. Richardson. Judge Richardson serves as United States Magistrate Judge for the Middle District of Florida. And prior to taking the bench, Judge Richardson served as an Assistant United States Attorney in the Middle District of Florida for over a decade. He also served as Executive Assistant United States Attorney, Associate Independent Counsel, Special Counsel to the United States Sentencing Commission, and briefly served as Chief Assistant United States Attorney in the Northern District of Florida. Judge Richardson began his legal career serving as law clerk to the Honorable Joseph W. Hatchett of the United States Court of Appeals, 11th Circuit. Our first panelist today is Rossana Arteaga-Gomez. Ms. Arteaga-Gomez is currently a partner at ACS Law Group in Miami, Florida. She practices in the areas of commercial litigation and criminal defense. She was previously a partner at the criminal defense firm of Black, Srebnick, Hornspan, and Stump, PA, and has also served as Assistant Public Defender in the Miami-Dade County. Ms. Arteaga-Gomez began her law career serving as a law clerk to the Honorable Marcia G. Cook, United States District Judge for the Southern District of Florida, and the Honorable Edwin G. Torres, United States Magistrate Judge in the Southern District of Florida. Also serving on our panel today, we are very lucky to have the Honorable Shaniek Maynard. Judge Maynard currently serves as United States Magistrate Judge for the Southern District of Florida. But prior to taking the bench, Judge Maynard was the executive director of the Roundtable of St. Lucie County, where she launched a program helping young men in gangs to find jobs, finish school, and to become successful members of society. Prior to that, she served as an Assistant United States Attorney in the Southern District of Florida. Last but not least, we have with us today Ms. Sowmya Bharathi. Ms. Bharathi currently serves as a Supervisory Assistant Federal Public Defender in the Southern District of Florida and has tried 22 felony cases to verdict, argued before the 11th Circuit Court of Appeals, and has extensive motion practice and appellate practice that includes habeas corpus matters. So with that, I will turn the panel over to the Honorable Monte C. Richardson, who will serve as our moderator for today.
Thank you, Rashad. On behalf of the American Constitution Society, I'm pleased and honored to serve as moderator today. I'd also like to thank President Green for his kind invitation to serve in this capacity. We have an excellent panel today, as well as 3 great cases to discuss. I'm going to moderate this panel on the bench. For this reason, I want to have it symbolize or basically follow what I do in a typical hearing. So what I'll do is let the lawyer speak, and I'll just ask questions accordingly. Now, Rossana Arteaga-Gomez will be discussing Jones versus Governor of Florida. That case was highly publicized last year, involving restoration of voting rights for ex-felons. Judge Maynard will be discussing Pitch versus United States, which involved disclosure of grand jury 6D information. And Sowmya Bharathi will be discussing United States versus Corinne Brown, which involves the dismissal of a juror during jury deliberations. So let's get started. With regard to Jones versus Governor of Florida, Rossana, give us an overview of the case and its impact moving forward.
Thank you, Judge Richardson, and good afternoon to everybody listening here today. So that case was decided in September 2020, right before the presidential election, and it determined something very important: under what circumstances convicted felons would have the right to vote in Florida. And so 2 years prior to that, Peggy, if you could show the text of Amendment 4. So 2 years prior to that, voters had passed Amendment 4. And you could read the entire text, but the important part of that amendment is what's circled there in red that says that all terms of service need to be completed before a convicted felon, all terms of sentence need to be completed before a convicted felon can vote. Thank you, Peggy. And Peggy, now if you could show the video guide to midterm.
Angel Sanchez is a member of the Florida Rights Restoration Coalition. The grassroots organization helped get the more than 1 million signatures needed to put Amendment 4 on the ballot. If it passes, anyone convicted of a felony in Florida would be eligible to vote after they've completed their sentence, including Angel.
The law took me away from Miami and the law brought me back to Miami.
Angel is now in his second year of law school at the University of Miami. But at the age of 16, he was convicted of attempted murder and armed robbery, served 12 years in prison.
The idea that someone can get out and pay taxes but never be part of the social fabric. We really believe in redemption and second chances, and we believe that Florida is a place where once a debt is paid in full.
And so the question in Jones versus Governor of Florida is, what constitutes that debt that Angel Sanchez is speaking about? Is it a convicted felon's term of imprisonment and probation, or does it also include fines, fees, and restitution? And so once Amendment 4 passed, the legislature had to also implement it, and it interpreted Amendment 4 as requiring the payment of fines, fees, and restitution. The Florida Supreme Court reviewed that interpretation and agreed. So in 2019, October of 2019, several indigent convicted felons challenged the constitutionality of Florida's payment requirement in a lawsuit filed in the Northern District of Florida. Some of the people, just to put it in context, the Amendment 4 passes, approximately 85,000 convicted felons registered to vote. And then after that, we still have approximately 915,000 convicted felons who would otherwise be eligible to register to vote, but for the payment of those fines, fees, and restitution. And so then the felons form a class and they file a lawsuit in the Northern District. And the main arguments advanced were that this pay to vote system, to adopt the dissent's description of the system, violates the Equal Protection Clause, the Due Process Clause, and the 24th Amendment because it constitutes a poll tax. So the district court issues a preliminary injunction finding that the plaintiffs are likely going to win on their wealth discrimination Equal Protection Clause claim. Months later, the 11th Circuit affirmed and declined to rehear the case en banc. The district court then proceeded to certify the class, goes to trial. There's an 8-day bench trial, during which the district court makes many findings. One is that many felons do not know, and some have no way to find out, the amount of their outstanding legal financial obligations, that Florida provides individuals inconsistent information, and that the state's own records are incomplete and unreliable, that Florida lacks records of restitution payments it has received, and that based on the state's own estimates, Florida officials would need about 6 years to determine how much the approximately 85,000 convicted felons who had already registered to vote owed, if anything. And then those 6 years didn't even account for the 915,000 eligible convicted felons who still hadn't registered to vote. So God knows how long it would take for the state of Florida to be able to determine if those 915,000 people still owed any money. And the district court also pointed out that the Florida puts the risk of error on the prospective voter. And Peggy, if you could show our audience the voter registration form. So you can see there, this Florida registration form, and there's a note, and it says, if the information on this application is not true, the applicant can be convicted of a felony of the 3rd degree and fined up to $5,000 and or imprisoned for up to 5 years. The district court ultimately concluded that Florida's pay-to-vote system violates the Equal Protection Clause, the Due Process Clause, and that it's a poll tax in violation of the 24th Amendment. The district court entered a permanent injunction. It agreed with the plaintiffs. The 11th Circuit then came in and stayed that permanent injunction right before the presidential election. The plaintiffs appealed to the United States Supreme Court, trying to vacate that stay, and the Supreme Court refused to do so. The 11th Circuit then reheard the case en banc. And so, Peggy, if you could show the John Oliver video.
Second, the most recent analysis found only 18% of felony convictions were for violent crimes of any sort, meaning the vast majority were for non-violent offences like property or drug crimes. And for those who have served their sentence but are still unable to vote, this situation is understandably frustrating.
At what point do we break the cycle? At what point are we able to say, hey, you know what? I am a citizen enough. You want me to work, you want me to pay taxes, you want me to make sure I take care of my family, but yet I can't vote. So am I a citizen or am I not a citizen?
Yeah, he's got a point, because that man is suffering taxation without representation. And historically, that's been a bit of a sticking point for America. I'm pretty sure I learned about that in school. Something about the American savages threw tea into the water without even having the common decency to add a splash of milk. So tonight, let's look at felony disenfranchisement, and one state in particular, because these 6 million disenfranchised voters are not evenly distributed around the country. In most states, people with felony convictions automatically regain their voting rights at some point, but there are a few where they do not. And the worst state of all concerning this, and arguably everything else, is Florida. Around 1.5 million of its citizens, nearly 10% of its adult population, have completed sentences for felony convictions but still can't vote. And given the iniquities of our justice system, that burden is disproportionately felt by African Americans, because in Florida, over 1 in 5 black adults cannot vote. That is staggering.
So what ends up being the fate of these convicted felons? The 11th Circuit says that voting is not a fundamental right, and that classification of convicted felon does not turn on membership in a suspect class such as race, religion, or national origin. And so therefore the law is subject to rational basis review, not heightened scrutiny. And it determines that Florida has an interest, a rational interest, in disenfranchising felons. It reasoned that the people of Florida could rationally conclude that felons who have completed all terms of their sentences, including paying their fines, fees, costs, and restitution, are more likely to responsibly exercise the franchise than those who have not. It also determined that it's not a poll tax. To debunk that argument, it said that, in effect, it's not a poll tax because it's a part of the person's punishment, the payment of these fees. And it also said that there's no due process violation because the law is very clear. You just cannot register to vote if you know that you owe money.
And Rossana, do you agree with the standard that was used by the majority, the rational basis test versus heightened scrutiny?
I believe that the dissent convinced me that heightened scrutiny is the appropriate standard. And so, that was a very good question, Judge Richardson, because I am about to discuss the dissent. So there were dissenters, and they explained that heightened scrutiny applied because Florida's pay-to-vote system created a wealth classification. And according to the dissent, Florida's pay-to-vote system results in a deprivation of the right to vote for felons in any election that takes place, essentially while they remain poor. It also determined that voting is a fundamental right. And it explained that even though that right can be abridged, states can pass laws to disenfranchise convicted felons, it doesn't change the nature of the right, and whether heightened scrutiny should be applied when access to that right is made to depend on wealth. So the dissent then goes ahead and says, well, even if heightened scrutiny doesn't apply, we're going to engage in a rational basis review. And it determined that there is no rational relationship between the disparity of treatment and some legitimate governmental purpose. It essentially says that it rejects the majority's view that there's twin goals with the passing of Amendment 4 for the Florida citizens, which is essentially either restore the voting rights of convicted felons who have paid all of their fines, fees, and restitution as part of their sentences, or continue to disenfranchise, the people who have not. And the dissent says that's not true. Amendment 4, that's not a goal of Amendment 4 to disenfranchise. It's supposed to do exactly the opposite. It's supposed to automatically restore voting rights to felons who complete all the terms of their sentence. And then it also goes on to say that it violates due process. And it says with respect to due process, voting is a fundamental liberty interest. And it explains how the law implementing Amendment 4 outlines procedures that fall constitutionally short for several reasons. So for example, if any of the 85,000 people who had already registered to vote had voted in the November 2020 election, they risk criminal prosecution if they still owe fines, fees, and restitution. And they also say that there's no procedure for a felon to determine his eligibility to vote before registering, even though the voter registration form requires the registrant to sign an oath affirming that they're qualified to vote. And that for approximately 915,000 people who still have to register to vote, if they do so and they're incorrect about the payment of fines, fees, and restitution, then they could also be subjected to criminal prosecution.
But Rossana, I think that the key point is too, you got to know what you owe, and that's the main crux of the issue. As you indicated earlier, and it's something that I was reading in the opinion that's really illuminating. As you pointed out earlier, as of 2020, the state of Florida, not just ex-felons, has been unable to determine outstanding fees and fines of ex-felons, even the 17 named plaintiffs in the case that we're talking about. The state has processed, as you indicated, 0 out of 85,000 pending registrations at that point, and the clerk's offices have been unable to find records of convictions, sentencing documents. So it's an institutional problem, correct?
Absolutely, Judge Richardson. And that was one of the issues that the dissent in that opinion really took issue with, is that the majority opinion said that Florida was not required to determine the amount that these people owed. And it said that the dissent, it took huge issue and said that they didn't know of any cases that say or hold that a state can impose a condition for the exercise of a right or privilege and then refuse to explain what the condition consists of or how to satisfy it. So that was a huge sticking point for the dissent, that the state of Florida itself can't even determine what these people owe. How could these people possibly be expected to determine it themselves and pay that obligation so that they can regain their right to vote? And then lastly, the dissent also explained that it did not view the requirement to pay these fines, fees, that it did view it as a poll tax. And that the reason is because there was no relationship between the fines, fees, and restitution owed and the crime. So somebody who is convicted of a very violent offense would be assessed approximately the same amount of money as somebody who is a non-violent misdemeanant who has pled not guilty and who pled no contest, denies the guilt, and the court has withheld adjudication. And so where does this leave convicted felons who want to vote today? They cannot knowingly register to vote if they haven't paid all fines, fees, and restitution associated with a criminal felony convictions. And according to the district court, good luck trying to figure that out. Thank you, Judge.
Thank you. So the effect, and I guess that's the question I want to ask you, what is the effect of the majority's decision with regard to ex-felons moving forward?
So moving forward, an ex-felon really would need to determine whether they owe any money, and they have to go, to the courthouse and try to figure that out. One of the problems that the district court pointed out is that you could be, you can be convicted of a felony and a misdemeanor at the same time, and then you would have to figure out what of those fees that you've been charged pertain to the felony conviction versus the misdemeanor conviction. And so imagine that's a really complicated process. And in fact, the district court found that it would take, based on Florida's own admission, that it would take 6 years for the state of Florida to figure out how much 85,000 felons would register to vote owed. So it's just for 85,000 felons, it would take 6 years. Today, I mean, if a convicted felon registers to vote and they're incorrect about whether or not they paid fees, they could be subject to criminal prosecution, and then their defense would essentially be, I was not aware.
And so in effect, if the state of Florida fails to centralize the information as far as the fines and fees for ex-felons, we're talking about a possibility of a permanent disenfranchised group unable to participate in the electorate.
Absolutely.
Yes, yes. Thank you very much. Moving forward, we have Judge Maynard, and she'll be talking about Pitch versus United States. And of course, Judge Maynard and I are both former federal prosecutors, and so we're very familiar with Rule 6E and secrecy. So Judge Maynard, you have the ball.
Thank you, and good afternoon, everyone, and thank you so much for inviting me to participate. Peggy, if you could go ahead and put my slides up, great. So this 11th Circuit case of Pitch versus United States is about keeping grand jury secrets. It involves the long-standing and sacrosanct rule that grand jury records, materials, proceedings are secret. I don't know how many federal criminal practitioners we have on the line or how many prosecutors, but those who do this work know that anyone involved with the grand jury must honor the secrecy rules. That includes the prosecutor, the jurors, the foreperson, the court reporter, the interpreter. The only person not covered by the rule is the witness, him or herself. If they want to talk about what they said, they can. But other than that, what happens in the grand jury room stays in the grand jury room. Next slide. So the majority opinion in this case was written by Judge Choflat, and the issue presented was whether the district court may order the release of grand jury materials in circumstances not explicitly covered by Rule 6E. The majority held that Rule 6E is exhaustive, meaning that the rule lists all of the reasons and all of the basis on which a court may disclose grand jury materials. The court said that a district court has no inherent supervisory power to authorize disclosure of grand jury records outside of the list 6E provides. Now, as I said, Judge Choflat wrote the majority opinion, but there are a number of concurrences and dissents, which hopefully we'll have time to get into. Next slide, please. So this case has a fascinating background. Anthony Pitch, who was an author and historian, petitioned the district court for the Middle District of Georgia for the grand jury transcripts relating to the investigation of the Moores Ford lynching. He wanted to use the information in his book about the lynching. For those who don't know, the Moores Ford lynching happened in 1946, and it involved the murders of 4 young African Americans, 2 married couples, by a mob of white men in Georgia. In July of 1946, a crowd of people dragged George and May Murray Dorsey, who's the couple on the left, and Roger and Dorothy Malcolm from a car and brutally murdered them. Mr. Dorsey had been a veteran who had served his country during World War II. Miss Malcolm was 7 months pregnant when she was killed, and the details of this crime are horrific. After killing Miss Malcolm, the mob literally cut her child from her body. Next slide, please. The case attracted national attention and catalyzed large protests throughout the country. The FBI and the Georgia Bureau of Investigations investigated the murder for 4 months in 1946. And this was actually the first time that the FBI had ever been ordered to investigate a civil rights case. A federal grand jury heard 16 days of testimony and over 30 witnesses. So I have to say, as a former prosecutor, at first when I heard the investigation was 4 months, I was like, that's not so long. Many investigations are much longer than that. But when I heard there were over 30 witnesses and 16 days of testimony, that was quite an investigation in front of the grand jury. But even with all of that, no one was charged with the murder. In the 1990s, publicity about the case led to a new investigation, but still there were no charges filed. Finally, in December of 2017, the FBI and the state of Georgia closed the investigation, saying they were unable to charge any suspects. So now fast forward to 2014, Mr. Pitch is writing his book, and he requests to have access to the grand jury's material. At first, the district court denied the request because there was no evidence that the records even still existed. A few years passed, and Mr. Pitch published his book in 2016. And in 2017, he learned that the records might be located at the National Archives. The district court reviewed the records in camera and ordered that the transcripts be unsealed. The district court found that the request did not fall within any of Rule 6E's stated exceptions, but said that a court may, in its inherent supervisory power to manage the grand jury, authorize the disclosure under extraordinary circumstances, and it found the case of the Morris Ford lynching, which at that point was over 70 years old, to be of such historical significance that the record should be disclosed. Next slide, please. So Judge Choflat, in writing the majority opinion, first recognizes the longstanding policy of grand jury secrecy and explains why that policy is so important. Grand jury secrecy serves several vital purposes, including you want to prevent folks who are being investigated and who may be indicted from fleeing. You want to ensure that grand jurors are free in their deliberations and make sure that people being investigated or their friends don't contact the grand jurors. You want to prevent perjury or tampering with grand jury witnesses. You want to encourage witnesses who have information on crimes to be able to speak freely. And lastly, you want to protect innocent people who are being investigated from other people knowing that they've been investigated by releasing or disclosing the investigation. Next slide, please. So here's the list that's provided in Rule 6E about when grand jury records may be disclosed. Grand jury records may be disclosed under Rule 6E in certain circumstances without court authorization, and then in other circumstances where there has to be court authorization. With respect to disclosure of records without court authorization, the rule provides that a government attorney may disclose grand jury materials to other government attorneys to perform official duties or to other grand juries to conduct investigations. In terms of circumstances under which records may be disclosed with court authorization, the rule provides that a court may order the disclosure of grand jury records preliminarily to or in connection with a judicial proceeding. So that's essentially if it's related to a judicial proceeding. The court may also authorize disclosure at the request of a defendant who shows that grounds may exist to dismiss the indictment based on something that happened in front of the grand jury. And then lastly, the court may also disclose grand jury records at the request of the government for use in a foreign state, tribal, or military criminal tribunal. Mr. Pitch, in trying to get the records from the Morris Ford lynching, argued that this list is not exhaustive. Rather, the 11th Circuit should view it as permissive. Mr. Pitch said permissive means it's just a list of suggestions or examples of when records can be disclosed. But a court also has the authority to go outside of this list to authorize disclosure in other exceptional circumstances. Circuit courts have been split on this issue, with the 7th Circuit and the 2nd Circuit agreeing that courts have this inherent authority to go outside of this list when ordering disclosure. And the DC Circuit, the 8th Circuit, and the 6th Circuit having said, no, this is an exhaustive list, and these are the only circumstances under which records can be disclosed. Next slide.
Well, Judge Maynard,
Sure, yes.
under the dissent in this case, they pointed out the advisory note under Rule 6, which enacted which was enacted, it indicates to continue the traditional practice of secrecy on the part of members of the grand jury, except when the court permits a disclosure. So it does indicate there is some support that is not exhaustive, that there is some discretion in order to release that information.
Absolutely. And the majority opinion really dismisses the notes to the rule, the committee notes, and says, we're just going to look at the text of the rule, and we don't see indication in the text of the rule that the drafters intended it to be, intended the court to be able to go outside of this list. So, you know, the court looked at things such as, it didn't use the word including. A court can disclose grand jury records in certain circumstances, including these circumstances. The majority opinion also looked at the fact that there was no residual clause saying the court could also fashion other reasons. So I agree, and the dissents do point out that there's some support in the advisory committee notes, but the majority opinion really just sticks to the text of the rule.
What about the fact that this is a cold case?
That was brought up by Judge Rosenbaum in her dissent. She said, pointed out that the fact that Congress in 2018 passed the Cold Case Act, I believe it was called. Yes. And the Cold Case Act essentially says that the National Archives have to figure out a way to disclose to the public information in civil rights cases between 1940 and 1979. And the Cold Case Act, in fact, relies on Rule 6E and says the district court can disclose records to meet the requirements of the Cold Case Act, can disclose grand jury records if there is a showing of particularized need. So Judge Rosenbaum really brings this up and says, look, you have Congress in a statute 2 years ago saying the court can disclose records if there's a particularized need under Rule 6E, but here we are in our majority opinion saying, no, that's not the basis under Rule 6E. So another very interesting aspect of this case is it overruled the 11th Circuit's prior opinion in 1987 in the Alcee Hastings case. So in Hastings, a judicial investigating committee sought access to grand jury records from the indictment of District Judge Alcee Hastings. He had been indicted on bribery charges for which he was later tried and acquitted, but the committee requested the information from the grand jury proceeding to determine whether he should be disciplined for violating the Code of Judicial Conduct. Now, in the Hastings case, a 3-judge panel speaking for the 11th Circuit noted that the request did not fall within any of 6E's exceptions, but held that a district court could release the records under its inherent authority. And the district judge and the 3-judge panel in the Pitch case relied on Hastings to find that the records should be released to Mr. Pitch. Next slide, please. However, as I've said already, the en banc panel disagreed. The court overruled its prior precedent in Hastings and said that 6E is exhaustive. This quote from the opinion that I thought was interesting said that not every beneficial purpose or even every valid governmental purpose is an appropriate reason to breach grand jury secrecy. Holding otherwise would allow a single district court to disrupt the balance struck by Congress and the Supreme Court to create such new exceptions as it thinks makes good public policy. So that, I think, concludes my slides, but as Judge Richardson mentioned, there were a number of very interesting concurrences and dissents in this case. Judge Wilson wrote a dissent in which Judges Martin and Judge Jill Pryor joined, saying Hastings has been our precedent for 40 years. It's based on a long history of common law finding that courts do have these inherent supervisory powers. And the dissent says, the majority says times have changed and it interprets the rule differently now, but our precedent should, quote, not zigzag back and forth based on the outcome of the case. So I thought that was an interesting line. We talked about Judge Rosenbaum's dissent. Judge Jordan wrote a concurrence saying the history of the grand jury secrecy rule is not as neat as the majority portrayed it. In England, the reason the grand jury proceedings were secret was to hide what the grand juries were doing from the king. He also talks about how in the 1800s, the grand jury was criticized because folks thought the reason it was secret was to give the government an unfair advantage. So he makes the point that it's not cut and dry, that grand jury secrecy is always viewed as a good thing historically. And Judge Jordan also recommends that the Rules Committee consider amending Rule 6E to include an exception for records of extraordinary historical significance. He notes that this was considered previously under the Eric Holder administration in 2013. And at that time, the committee said courts already have the inherent power to do this. So Judge Jordan says, well, now we see there's a split in the circuit, and we need to encourage the Rules Committee to go back and look at Rule 6E.
Thank you, Judge Maynard. That was excellent. And moving forward, we have United States versus Kareem Brown. I'm familiar with that case because actually the case was tried here in the Jacksonville division by one of my colleagues, one of the district judges here. Sowmya, Bharathi, if you want to present, you have the ball.
Thank you, and thank you all so much for inviting me here. And I've learned a lot just listening to the other speakers, so I'm really happy to be here. You know, like Your Honor just mentioned, you know, the case was tried up in Jacksonville, but folks may be familiar with this case because the headlines that kind of swirled around it posed it in terms of a case that presented Satan versus the Holy Spirit. And, you know, the question really was, you know, deliberating jurors are allowed to pray for guidance and for wisdom. We know this, but what happens when a juror says that he's prayed to God and he heard God answer? He heard God answer his prayers. So this case of former US Congresswoman Kareem Brown is just a perfect example, I think, of the unique challenges faced by trial courts and trial lawyers. You know, in removing a juror during deliberations in a criminal trial, it was agreed that the district court applied the correct legal standard. But in trying to balance the competing considerations of, you know, we've been talking about secrecy, respecting the secrecy of the jury, but also ensuring that the parties receive a verdict that's rooted in the evidence that's presented at trial and guided by the applicable law, the district court is in a position where it has to walk a fine line with its inquiries when there are allegations or accusations of juror misconduct. And if that's not difficult enough to do, in this case, the fulcrum of the issue, it pivots on what was described as an individual juror's very sincere and very earnest religious beliefs. So obviously there's a very wide spectrum in our country of how individuals might view or experience or express religion or prayers. And here I think the district court had a very tough job because it had to grapple with what I think most people would agree is a very profound and complex issue. You know, how does a person's faith impact his decision-making process in the confines of our legal system? So while the initial 11th Circuit opinion affirmed the conviction, that opinion was vacated and set for rehearing en banc. And the oral argument in that case recently occurred, and it's available online for anyone who is interested in listening. It's really interesting. Judge Jordan, you know, posing great hypotheticals, and all the judges and lawyers participating, doing a great job. But the issue, there's numerous issues that were raised, but the main tension revolved around the question of what conclusions could be drawn from the record evidence, where the district court questioned the dismissed juror who stated, "The Holy Spirit told me that Kareem Brown was not guilty." So just by way of quick background, you know, Ms. Brown was convicted after 8 days of trial. I think there was about 40 witnesses, you know, hundreds of exhibits. And each of the sitting jurors, of course, affirmed that they held no religious belief that would preclude them from serving as a fair and impartial juror or would impede their ability to sit in judgment. And all of us who have been in the courtroom and as trial lawyers, we know, we're very familiar with that language. And they also swore to render a true verdict according to the law and the evidence and the court's instructions. And that oath is taken, so help them God. And so they retire to deliberate. They begin on the first day right after lunch. They go home. They come back the second day. And at the end of the second full day, juror number 8, who is not the foreperson, makes a statement to one of the judge's staff that she has concerns about juror number 13. And that from the outset of deliberations, juror 13 has been speaking of quote unquote higher beings in connection with Ms. Brown. And so of course the staff instructs the juror, we can't discuss this, and immediately informs the judge. And the judge, of course, the next morning, day 3, consults with the lawyers. And the government and the defense want the judge to inquire of juror 8. And according to the opinion, the panel opinion, the judge reluctantly agrees. So I think right there, it's important to note that the court is very cognizant of the tension of invading the juror's secrecy. But the judge agrees and brings juror 8 out. Juror 8 has prepared a letter. And in that letter, juror 8 writes, and I believe she reads it to the court, that she's a little concerned that when we began deliberations, juror 13, and I'm going to use quotes just because I want to make sure I'm getting the language right. A higher being told me Corinne Brown was not guilty on all charges. Later, he said he, quote, trusted the Holy Ghost. The jurors asked him to base his verdict on the evidence, testimony, and law. And she says, juror 8 says, quote, other jurors share my concern. So the district court tries to hone in on the timing of the alleged statements, because remember, this questioning is occurring day 3. The alleged offending comment was made day 1, and a whole at least day of deliberations was made before juror 8 made this comment to the staff member. So the judge determines based on his questioning that the statement was made when the jury first went into deliberation. And that will be important in the 11th Circuit opinions, because the arguments later as to whether juror 13 had formed a conclusion without deliberating with others, or whether there was sufficient evidence about the process that the jurors had established when they entered into the jury room. So there's a importance there with the timing. And, you know, juror 8 says that since day 1, juror 13 had not made additional statements to the same effect. It appeared juror 13 was deliberating, and nothing about the situation was interfering with juror 8's ability to deliberate. So the defense counsel then asked some questions, and they elicit that juror 8 says, no other juror has asked me to come forward. I don't even know if the other jurors know that I am here doing this, and that she only learned of the other jurors' concerns while they were all deliberating as a whole jury in the presence of juror 13, which is again, of course, important because it indicates that they're all communicating with one another in the manner that, you know, we would expect, and not, you know, breaking off into groups and speaking outside the presence of each other. So at that point, the government asks the court to question the foreperson. And the defense counsel says, I don't think there's any further steps needed. And at this point, the district court does make explicit acknowledgements that, of course, praying for guidance is absolutely acceptable. And there is a suggestion that's made that juror 13 be brought out. So juror 13 is brought out, and he's asked a large number of questions. And again, you know, I'm not going to go through them all, but I would, you know, sort of recommend folks to look at it, especially if you're out there trying cases. Juror 13 affirms that he's not having any difficulties with any religious or moral beliefs that are interfering with his ability to understand the law or, evaluate the evidence. And he's asked, have you invoked a higher being? And he says, absolutely. I told them I prayed about this. I've looked at the information. I received information as to what I was told to do in relation to what I heard here today or this past 2 weeks. And the judge asks, are you saying you received information from? And there's sort of a hyphen in the transcript. And the juror says, my Father in heaven. But then the juror goes on to confirm, I'm basing my decision only on the evidence presented, and I've been doing that. And my religious beliefs are not impacting my ability to participate. And I'm making my decision. I'm going to read this part because I think it is important. He says, my religious beliefs are going by the testimonies of people given here, which I believe that's what we're supposed to do, and then render a decision on those testimonies and the evidence presented. So the court crafts one additional question, and the answer that is given in response is what the 11th Circuit has started calling the radioactive answer. But the court crafts one more question, and neither party objects to the question, which is, did you say a higher being told me that Corinne Brown was not guilty on all counts? And the juror 13 says, no, I said the Holy Spirit told me that. I mentioned it in the very beginning when we were on the first charge. So the district court ultimately dismisses juror 13, and Ms. Brown's conviction was affirmed by a 3-judge panel of the 11th Circuit, which held that the district court had not committed clear error in its factual findings, and it did not abuse its discretion. And the district court employed the correct legal standard, which is that a juror should be excused during deliberations for good cause. And, we know good cause is that there is no substantial probability, or it's really a beyond a reasonable doubt standard, that the juror is basing his decision on the sufficiency of the evidence. Because there are these competing interests, right? We don't want to dismiss a juror who maybe is rejecting the government's evidence, but we also want to make sure that the parties have jurors who are basing their verdicts on the evidence that's presented in trial, as well as the court's instructions. And so what's important are the factual findings, as the 11th Circuit frames them, that the district court made. In dismissing juror 13, the 11th Circuit says the district court found juror 13 was very earnest, very sincere. He stated he is receiving information from a higher authority as part of his deliberative process, and that the statement was made early on without discussion with his fellow jurors and in violation of the court's instructions, and that he was using external forces to bring to bear on his jury service. And that necessarily impacted his overall deliberations. And at bottom for the district court, it said that the Holy Spirit told him Corinne Brown was not guilty. And for the district court, that was, quote, a bridge too far. So on appeal, the standard of review is that, an abuse of discretion, and will only reverse if we find that, the court discharged the juror without factual support or for a legally relevant reason. And the dissent written by Judge Pryor is really interesting because he looks at the same factual findings and says the record was limited and did not satisfy the tough standard that we should require district courts to deploy before dismissing a juror in the midst of deliberation. And from Judge Pryor and the dissent's point of view, Juror 13 made repeated, specific, and sincere assurances that he was basing his decision on the evidence as his religious beliefs instructed him to do. In addition with the fact that Juror 8 had affirmed Juror 13 was deliberating, and also finally in what Judge Pryor says is an absence of evidence of confirming misconduct by Juror 13. So what really hits home, I think, about the difficulties that judges have and trial lawyers too, is, Judge Pryor says this runs the risk that judges could misinterpret religious language. And Judge Pryor focuses on the word vernacular that was used by Juror 13. And in his position, he said, under the majority's opinion, many eligible jurors would be stricken if a lawyer elicited during voir dire that God communicates with that potential juror. So it's very interesting because really, what does it mean that the Holy Spirit, quote unquote, told juror 13 that the defendant was not guilty? Obviously hindsight being 2020, we could say that, the district court perhaps could have inquired a bit further and asked, a little bit more. But even still, when you read the dissent, had the juror said, I ask a question and I hear a responsive voice, I'm not sure that that would have resolved this case. There's a lot of, sort of academics and intellectuals out there that have talked about how individuals experience religion, experience their relationship with, what they perceive to be the divine. So it really does put judges and lawyers on notice that we have to become very sensitive and aware that we have to start asking these types of questions. And how do we balance that, right, with protecting the interests, all of the different interests, the religious interests, the Sixth Amendment interests, and the secrecy issues that come to bear when you're actually in a jury trial.
You're right, Sowmya, and just going back on your point with regard to Judge Pryor, I was reading his dissent, and like you indicated, he was indicating that the person was speaking in the vernacular. But he also pointed out, he said that, and get this quote right, I believe he said, African Americans and evangelical Christians believe they communicate with God at a higher rate than other groups. I found that interesting. He made that statement. Now, I do know that people I grew up with, they use that expression quite a bit. The Holy Spirit, God tells me this. Absolutely. So absolutely, I understand what he's saying. But it's a very difficult tightrope that judges have to go through in order to pick jurors. And it's certainly a very private matter on Bharathi. If you ask these folks questions and you get real personal with them, you run the risk of offending them. And so that's always an issue.
Absolutely. Absolutely. And, on sort of like a mechanical, practical, on the ground aspect of this is, when is the right time to get into this? Usually at the initial voir dire, we just ask folks if they have any strongly held beliefs that might impact them. But, we don't generally delve deeper into that and say, tell me about your personal relationship with what you perceive to be the divine. So there is this issue, right, where if this comes up in a deliberating jury context, how judges and lawyers are supposed to walk the tightrope of finding that out. I mean, we've, judging from the oral argument, some judges thought perhaps bringing out the foreperson to kind of gauge what was happening might be the right way to do it. But we all know that you run a risk when you start bringing out deliberating jurors one at a time, and you want to be protective of their sort of perception that they get to be in this bubble of secrecy.
Without a doubt. Thank you very much. And I believe we're out of time. I'll turn it back over to Rashad Green.
Thank you, Judge. And so during the discussion, and also thank you to all the panelists, your presentations were outstanding. We do have a couple of questions from the audience. Two are directed at the Jones case, and then one for the Pitch case. So we'll start with the Jones case with you, Rossana. It says, in Jones, as I recall the case, the 11th Circuit decided to hear the case en banc first, rather than send the case to the panel first. Should it have done so? And what impact, if any, did the procedure have on the outcome? Also, what impact did the recusal decisions in the case play on the outcome, if any?
So I'll start with the beginning of that question, and then I'm going to ask you to tell me the rest. Sure. So no, there was a panel decision first, and that was the appeal of the preliminary injunction order. And then after the court, the district court entered a permanent injunction, then there was a stay by the 11th Circuit and an en banc review. And so what was the second part of that?
So the second part was, what impact, if any, did the procedure have on the outcome? And I guess you kind of answered that, but if you want to, speak to that.
Yeah, no, I mean, the en banc panel the en banc court reviewed the panel decision, and it completely overturned it. And it was something that actually the Supreme Court's dissent, when it gets appealed to the Supreme Court, the 11th Circuit stay of the permanent injunction gets appealed to the Supreme Court, and Sotomayor wrote a dissent criticizing how the 11th Circuit was essentially completely turning around, doing an about face.
Thank you. And there's another question with respect to pitch. Judge Maynard, I guess this would be for you. In pitch, do you think it was necessary for the 11th Circuit to overrule Hastings, as the factual basis for Hastings was different from the facts before the case in pitch? Why did it do so, while at the same time offering a separate legal basis for Hastings that differed from the legal basis in the original Hastings decision? And if you need me to repeat some of the question, I'd be happy to do so.
So I think it was necessary for them to overrule Hastings if they wanted to go where they wanted, if they wanted to get where they wanted to go, because in order not to overrule Hastings, they would have had to say this exception around relating to judicial proceedings actually encompassed Hastings. And in a sense, they said that in a concurrence. But one of the things I thought was interesting, and I think the concurrence went over this, is that Hastings was actually not decided by any of the members of the 11th Circuit. All of the judges from the 11th Circuit were recused for Hastings because he was a district judge in the 11th Circuit, and the Supreme Court appointed a 3-judge panel from of judges from other circuit courts. So I asked myself that same question: do they really have to go so far as overruling Hastings? But I almost got the sense that they did that to just say, Hastings was wrongly decided, even if it reached the right outcome. We are going to just say Rule 6E is exhaustive, and that be that. The other question that I saw was whether the 11th Circuit should have given the Cold Case Act and Judge Rosenbaum's concurrence more weight. And I thought that raised this really interesting issue when we're talking about how do we interpret legislative intent. The majority said, we're not going to look to things Congress does after they pass the rule to see what they meant by the rule. That's too much of a chicken and egg. The rule comes first. So why would we look at what Congress did after the rule to determine what the rule means? But I think Judge Rosenbaum brought up a great point, that it's the congressional branch that is legislating the rule and legislating these statutes. So we need to look to them to see what they mean by this. Another sort of interesting thing is that the rule was enacted in 1946, which was the same year as the Moore-Ford lynching. So do we look and see what they meant in 1946, or do we look and see what Congress means today when it talks about Rule 6E? So all very interesting issues.
Thank you, Judge. And there's one more question, and this is to the panel, to anybody who wants to respond. Do any of you have a sense if the 11th Circuit is taking more cases en banc? The person who wrote the question noted that each of these cases went en banc, and if so, why do you think this is happening?
I mean, I can take a stab at it, although I haven't looked at the hard numbers. So, I mean, I could definitely be incorrect, but I think the number of en banc cases has definitely increased, at least in my 15 years here at the Federal Defender's Office. We're seeing more and more. So I do think it has increased. I think there's a lot of reasons that cases can go en banc, but I think the simplest is if you have a 3-judge panel opinion and there's one member polled and then a majority of judges think that it should be heard, it's kind of just the simple math of what the composition of the court is and what they believe are the important legal issues that need to be sort of addressed as a whole court. Obviously panel decision, 3-judge panel decisions, we get lots of those. And so where they believe there either needs to be consistency or a clear answer, there's a lot of different reasons why it could be happening.
Anybody else want to chime in? All right, well, that concludes our presentation for today. Thank you so much to our panelists and our distinguished moderator for being with us today and supporting ACS. And like we said at the beginning, if you want to know more information about ACS, please feel free to visit us at acslaw.org. Thanks, everybody, and we look forward to seeing you soon.
Thank you.